Yes, welcome back, everyone. Welcome back. Welcome back. By now, I'm sure you know me since, well, this is the last recording of our semester. But for anyone who somehow missed it before now, I am Patrick McGinley. I am your friendly neighborhood bar grievance defense attorney, by which I mean I'm proud to defend my fellow members of the Florida Bar and the District of Columbia Bar against bar grievances, ethics complaints, and ethics investigations. Thank you for allowing me to be your instructor for your professional responsibility class this semester. It's a joy to share with you these model rules and from time to time my insight into them. I hope I've been helpful to you in your practice and helpful to you in practicing to take the MPRE, the exam, and of course my final exam's coming up, so hopefully I am teaching what I test and testing what I teach, because that is my goal. Also, to the extent I can be, because I'm a lawyer, not a comedian, but to the extent I can be, I'm trying to be animated, I'm trying to be entertaining. To that end, I've added it to the bookshelf. Do you see it right there? Do my best to point at it. That, I hope you can tell, is an elephant. Yes, just to prove that. Get a little closer for you. See, that's an elephant, right? So took the cast iron elephant, put it right about there, which means from time to time, when my head is just right, I'll have an elephant on top of my head. And why do that? Well, everybody needs a good drinking game, by which I mean milk. Drink milk. Milk, it does a body good. Strong teeth, strong bones. When should we drink our milk? Well, how about every time I lean back enough to have an elephant on my head? When you see an elephant on my head, have a drink of milk. And that will not only give you strong teeth and bones, but give you something to do and keep you awake and motivated through this, our very last lecture. Okay, hey, at least I laugh at my own jokes, even if no one else does. All right, so we don't have much else to cover. In our textbook, we're on the very last chapter or lesson, as our author has decided to label them. Lesson 19 is the very last one. But as you know, I jumped ahead and I skipped over to prior chapters or lessons. Lesson 4 and Lesson 5. Lesson 4 talks about judicial conduct. Lesson 5 talks about judicial conduct outside activities. Ironically, they were very early in the book, which isn't true for a lot of books on professionalism, professional conduct, and the model rules of professional responsibility. I'm a bit of a connoisseur of these books. Got quite a few of them here on the shelf. Got that one. See, that does not start by talking about judges. I got this one. It didn't start with talking about judges. I got those 4 and these 3. Here, get you zoomed in over there. See, I got all these books here. None of those books start by focusing on the judicial rules. But our book did. Got to get the elephant just right. Where'd the elephant go? Okay, grab your milk. But our book did. So I defer to the other authors. I think it's best covered at the end of the semester. So that's what I've done. Forgive me for skipping over lesson 4 or 5 or chapter 4 and 5 and putting it to last. But I think that was the appropriate place to cover it. And so did all those other authors that I just showed you. So with that said, let's get this just right. Elephant. See, I shouldn't have moved it because I had an elephant on my... There you go. Have a sip of milk. Okay. And with that said, let's dive right into it, shall we? Okay, let's begin at the beginning, which is something I promised to cover in our last class, but after 3 hours and 3 minutes of speaking, I left it off. I'm sure we can go shorter, not a full 3 hours and 3 minutes this week. I say that every week, and I don't always keep that promise. Let's see if I can keep that promise this week. So we're looking at Model Rule 3.6. 3.6 talks about trial publicity. And, obviously a criminal trial, can be quite different than a civil trial, can be quite different from an administrative proceeding, can be quite different from an appellate proceeding that arises out of any of those. But this model rule 3.6, it applies regardless of whether it was civil or criminal, trial or appellate, administrative or not administrative. You're always dealing with the rule 3.6. And it's saying there that we lawyers aren't supposed to make extrajudicial statements, meaning statements outside the courtroom, if the purpose of those statements is to prejudice the proceedings. The model rule goes so far as to say that it's incumbent upon us to determine whether it's likely that this statement will prejudice the proceedings. And if it is likely to prejudice the proceedings, then we're not supposed to make the statement. So the model rule imposes a great burden upon us, which may or may not be true in your particular jurisdiction. In your particular jurisdiction, if you're intending your extrajudicial statements to affect the outcome of the proceedings, then that's a violation. But under the model rules, we have an even higher standard. We're supposed to know, even though we might be speaking off the cuff, we might be at a press conference, we might be on the spot and a reporter asks us questions. Under the model rules, we've got a responsibility to think on our feet. We've got to determine whether or not the statement we're about to say out of our mouths is likely to prejudice the proceedings. If it's likely to prejudice the proceedings, then we're not supposed to say it. So what if I'm just talking generally about the claim? That's, I think, fair to say that that's not likely to prejudice the proceedings, just the allegations of the claim. Likewise, what if I'm just talking about the allegations of the defense? Again, just the defense. Again, elephant, grab your milk. If all I'm talking about is the defense, then that, I think it's fair to say, is not a statement designed to prejudice the proceedings, probably not even likely to prejudice the proceedings. What about if I talk about information? Well, that's going to turn sometimes on whether or not that information is in the public record. If it's public record information, then I think it's not only fair to say that it's not designed to prejudice the proceedings, but it's not even likely to prejudice the proceedings because it's already in the public record. Even if the reporter puts you on the spot and asks you some questions, that reporter has access to the public record. That reporter might report that information regardless of whether or not you talk about it. So you're probably okay under either standard for that kind of information. Request for assistance regarding evidence or information. That's okay. That's okay. Say there's a missing witness and you happen to find yourself in front of a reporter and you take this opportunity to say that you'd like that witness to come forward if that witness is out there. That's okay. That's okay. That's permissible under the model rules and more likely than not, the rules of your jurisdiction. So that's okay. What if you're looking for information? Same thing as a missing witness, missing information. While you happen to find yourself in front of the reporter, that's okay to talk about that. So that's okay. Our author suggests that it's okay to give a warning about a person that's dangerous. You know, our author goes out boldly and says that. I think that would depend on the particular facts, you know, because that is certainly likely to prejudice the proceedings in a given set of facts. So I wouldn't have been as bold as our author is to just say blanket, point blank, it's always okay to give a warning about a person if that person is dangerous. I think I would have scaled that back had I been the author and said more likely than not, or in most cases that that's okay. But I think you and I can foresee situations where that kind of information would meet a standard such as likely to prejudice the proceedings. What about if the other side gave a statement and that statement from the other side is likely to prejudice the proceedings? Well, under the model rules, now you have greater license, greater rights, greater ability to make a statement because you get to offset the effect of their statement with your statement. So if you're rebutting the other side's public statements, then your public statements can probably go a little bit farther under the model rules than they would be able to do otherwise. So that's a great example that our author pointed out in wrapping up her chapter 19, her lesson 19. So that covers the uncovered part, if you will, from last week. That covers the last part of Lesson 19, the Roman numeral 2, the trial proceedings. But I think it's always worth taking a closer look at the particular model rule itself. And that's certainly worthwhile to grab your model rules book and take a look at the specific language of model rule 3.6. You've got your own model rules book, so you can look at the language yourself. I'll just paraphrase here. So over here, you've got a list under model rule 3.6b, which is like a safe harbor. It's a list of things that the model rules say that notwithstanding your obligations under paragraph A, these things in your safe harbor list of paragraph B are always safe to say. Number one talks about, like we did, talking about the claim or the defense. And unless the law of your jurisdiction says otherwise, then you can talk about identities of the people involved in the trial. That's all under your safe harbor list, number one. Number two is that public record again. Number three is an investigation of a matter that's in progress. Number four is about a scheduling event or the result of a litigation step. You know, we won the motion, we lost the motion, we excluded the evidence, we got the evidence admitted into evidence. That kind of thing is number four. Number five is that request for assistance. Hey, I'm looking for this witness, or we're looking for greater information about that. That's your safe harbor of number five. Number six is that warning about the dangerous behavior. And I guess it was the motivation of safe harbor number 6 that prompted your author in her chapter 19, her lesson 19, to just come out and say, it's always okay to talk about a warning of a person if dangerous. But, you know, I think I should read the full sentence, and you should read the full sentence of Model Rule 3.6 sub B sub 6 and look at how that compares to what your author said. Here, let me read you the full sentence here. Notwithstanding paragraph A, a lawyer may state, number 6, a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. So compare that to your author's bold statement that it's always safe to give a warning about a person if dangerous. That's not exactly what the model rule says, right? The model rule requires more. The model rule says if there's reason to believe there's a likelihood of substantial harm to an individual or to the public interest. I'm trying to get that elephant right there. There you go. So the model rule says if. It's kind of like, is there an elephant on my head or is there not? If there's an elephant on your head is different than there could be an elephant on your head. That's a poor analogy, I guess, to compare what your author said versus what the model rule says. But my point is this: the model rule can be interpreted, and in my opinion should be interpreted, to mean sometimes you can't give a warning about a person if dangerous, because the model rule says you can only do that when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. And this is not the first rule that talks about substantial harm, right? You remember last week's lessons when we focused on the duty of confidentiality, how the jurisdictions differed based on whether there was substantial bodily harm. So precedent exists for interpreting these model rules to carve out substantial versus not substantial. And I wish your author had carved that out there in her lesson 19. So I don't mean to criticize so great a book that we've been studying from all semester, but nothing is flawless. Your book is no exception. I would have phrased that exception differently. I would have given a better paraphrase, in my opinion, because it's only if there's a likelihood of substantial harm to an individual or the public interest that you can go around calling other people in your litigation dangerous. So watch out for that. All right, now look at subsection C. Notwithstanding your obligations under Model Rule 3.6, A lawyer can make a statement that a reasonable lawyer would believe is required to protect a client from a substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So that's what I was talking about earlier when I said that if there's already been an extrajudicial statement by the other side, that can give you greater license, greater liberty, greater ability to say more than if there hasn't been, because of this mitigation ability that you're granted within Model Rule 3.6 sub C. That mitigation ability allows you to say more if they spoke first. So that's an important thing to remember. And the last closing sentence of Model Rule 3.6 reminds us that we can't do through others what we are unable to do ourselves under the model rules. Gives us that reminder yet again when it tells us that if you're associated in a firm or if you're part of a government agency, any lawyer associated with that firm can't make a statement that another lawyer in the firm would be prohibited from making. And you already knew that because you know that concept is in the model rules and is repeated throughout various other rules and says how if you can't do it yourself, then you can't instruct others to do it on your behalf. You knew that. And this Model Rule 3.6 closes with another example of exactly that. So no confusion there. And for that reason, I think it's always worth taking a look at the actual text of the model rules when you're trying to interpret our particular textbook. But as you can see there, is a very valuable reason to do it there. Now, our next topic talks about withdrawal. It talks about when you can quit, but more importantly, it talks about when you should quit. Speaking of quitting, I always like to give you all breaks, even though you're watching on the videotape. Some of you are in a position where you can't fast forward. Some of you are watching live. For those of you, you need your breaks just like those who are watching the replay and can hit pause. So this is the first of our 2 breaks today and the shortest of the 2. But when we come back, we're going to take a look at those model rules again. Get your model rule book ready, or better yet, look at it on the internet. It's free to view. It's not behind a paywall like the ABA's advisory opinions are. So take a look at it there. Pull up Rule 1.16, and when we come back, we'll talk about quitting and withdrawing. See you in about 5 minutes. Well, hi, welcome back from the break. I know what you're thinking. You were thinking, hey, where'd Patrick McGinley go? I'm here. I'm back. Hope you didn't miss me. All right. So, as promised, I am back after the break, and we are here with our new topic. Our topic to discuss is attorney withdrawals, attorneys quitting, attorneys no longer serving as the attorney in the matter. What we're talking about then is Model Rule 1.16, which you'll want to turn to in your friendly neighborhood model rules book so you can follow along with your friendly neighborhood bar grievance defense attorney, yours truly. Okay, so Model Rule 1.16 is adopted substantially in most, if not all, jurisdictions. So the concepts from the model rules will carry through and true to you in your everyday practice. Also, if you're getting ready for the MPRE, which I know most, if not all of you are, you're going to need to know these model rule concepts and apply them there to get the questions right. So what are the issues that we're looking at? Well, we're looking at permissive withdrawals and we're looking at mandatory withdrawals. When we look at permissive withdrawals, what we're talking about is when is it so that a lawyer is allowed to quit? By comparison, when we're looking at mandatory withdrawals, we're looking at when is it so that the lawyer must quit? And take that to heart. When I say must quit, in a mandatory withdrawal situation, if the lawyer fails to quit, the lawyer is subject to discipline. Arguably, if the lawyer's quitting is untimely, arguably the lawyer could be subject to discipline. But of course, untimely under certain facts are going to be in the eyes of the beholder. What might be untimely in one person's opinion might not be untimely in another. Where you really run into trouble under these concepts that arise from the model rules is if you've got a situation where it is inarguable that the lawyer needs to quit and that any reasonable lawyer would understand their obligation at that point to quit, and yet the quitting is still delayed or non-existent. At that point, you've got a violation of these concepts that arise out of the model rules when it comes to a mandatory withdrawal. I remember in one proceeding where I was defending my fellow lawyer against a bar grievance, the referee, which here in Florida is what we refer to as the judge who is appointed by the Supreme Court of Florida to actually hold the evidentiary hearing, to hold the trial. The Supreme Court of Florida is the ultimate arbiter of the findings of fact and the conclusions of law, but they aren't physically holding the trial, admitting and denying evidence, listening firsthand to the witnesses. They delegate that duty under the rules regulating the Florida Bar Chapter 3 to a judge who serves as their referee. So I'm in front of the referee, and the referee is talking colloquially about whether or not there was a duty to withdraw. She's talking about when was my client on the bus and when was my client off the bus, and when was my client supposed to be on the bus and when was my client supposed to be off the bus. And these were colloquial terms that she was using, but I respect her for using them because it's a beautiful analogy and you might want to use it too. Think of being on a bus or off a bus. There are times where to get where you're going, you're going to need to ride the bus. There are times where the bus is taking you where you don't want to go, and you're obliged to get off the bus. So I think her analogy was a beautiful one and a useful one when studying the concepts that arise out of Model Rule 1.16. So you might want to adopt that mindset yourself. You may prove helpful to you. So Model Rule 1.16a talks about when a lawyer shall withdraw. So A is talking about that mandatory withdrawal situation. B talks about when a lawyer may withdraw. So B talks about the permissive withdrawals. Let me start with the easier part. In my opinion, let me start with the permissive withdrawals. So these are the concepts you find reflected in Rule 1.16 sub B. When can a lawyer quit? Once you're on the bus, must you forever stay on the bus? My argument is no. Despite having a license to practice law, you remain in control of your work-life balance. Just like any profession, the professional must take control of the work-life balance, or work and life fall out of balance and the professional finds him or herself in personal trouble. Now, think about it, if you will. Our profession is often criticized for the fact that members of our profession find themselves in higher percentages of instances of substance abuse than in many other professions. And there are professions where the professional has access to substances, right? I think about some of the medical professions. Obviously, the typical lawyer doesn't have any access to any substances, but yet we as lawyers, percentage-wise, have higher instances of substance abuse. So what's going on there? And of course, that's a complex question that can't be given a simple answer. But perhaps you would agree with me that sometimes the answer lies in the fact that the work-life balance ran amok, fell out of balance, was not balanced. You know, there's a time and a place for everything under the sun. There's a time to work hard, but there's a time to play hard. There's a time to earn money to support your family, and there's a time to be with and spend time with your family. There's a time where we need to focus on advancing our careers, and there's a time where we need to put our careers aside and enjoy the fruits of our labor. There are times where we've got to burn the midnight oil, and there are times where you need to get out of the office, get some fresh air, be with a loved one, watch a child play sports, be with a parent for their birthday, help an elderly parent, help a younger child, spend quality time with a spouse, a partner, a loved one. Come on. The list goes on of things you need to do besides working your client's case or transaction. That's what I'm talking about when I talk about work-life balance. That's the concept we talk about in Model Rule 1.16 sub B. You are permitted to withdraw in a myriad of situations. Some of the examples there. And with a catch-all. The catch-all after the examples is other good cause exists for the withdrawal. I humbly suggest that work-life balance is one of those other good causes. You know, when a lawyer meets a potential new client for the first time, it's not just the potential new client who's interviewing the lawyer to potentially hire the lawyer. It's also the lawyer interviewing the client and the client's situation and the client's case to see if this is a burden the lawyer wants to help shoulder. You know, good screening out of bad situations is important. There may be, for personal reasons, cases you don't want to get involved in. That initial consultation, that's the time to just not get involved in the first place. But Model Rule 1.16 and the concepts found in subsection B's permissive withdrawals are our safeguard when we weren't able to filter out those bad cases. And we find that they're having a bad effect on our work-life balance. They're having a bad effect upon our practice. They're having a bad effect upon our firm. They're having a bad effect upon our marriages or our lives. That's when you've got to make use of those permissive withdrawals. You've got to keep work and life in balance. And this model rule and the concepts from it can help you do that. So let's take a look at numbers 1 through 6 of the examples that end with number 7, which is that catch-all of other good cause for withdrawal exists. Don't forget that catch-all number 7 makes this list 1 through 6 we're about to look at a non-exclusive list. Just because it's not in numbers 1 through 6 doesn't mean it's not a ground for permissive withdrawal. If it's an other good cause, then you can, and perhaps maybe even should, but certainly can withdraw. Let's look at numbers 1 through 6 with that number 7 in mind, shall we? Number 1 talks about when you can withdraw without a material adverse effect on your client's interests. That can be almost any time if you withdraw properly. I like to phrase it this way. The rules don't allow us to cut and run. They don't allow us to drop the ball, by which I mean you might have to do some things to protect the client's interest on the way out the door. So your withdrawal can't be a cut and run. It can't be instantaneous. You might have to slow down and take a few preliminary steps in order to best protect your client's interest before withdrawing from the case. For example, if it's a litigation case, you might have to have some names ready of lawyers who are willing and who are able to take on such a case and take it over from you. Depending on the rules of your tribunal, that lawyer might have to be located in advance and might have to sign the motion to withdraw with you. In any tribunal, it's almost always true in that tribunal's rules of procedure that you will need the presiding judicial officer's permission to leave a litigated case. We refer to this as a motion to withdraw. The motion to withdraw is almost always required by the rules of a tribunal. So if there is a litigation going on, be it civil, criminal, administrative, you've got to get the motion to withdraw granted, not just filed, granted before you withdraw. What do I mean by that? Well, say you've got more than good cause to withdraw. Say you've got a client who isn't even responsive to you. Can you fire off email number 7 after emails 1 through 6 asked for a response and got none, and simply state in email number 7, you didn't answer emails 1 through 6, and it's been weeks. I'm giving you 48 hours to answer this one, and if you don't, I'm simply not showing up for your trial next week. You're on your own. No, can't do that. Why can't you do that? Because even in this scenario of a permissive withdrawal, you've got to do it without an adverse effect on your client's interests. And you've got to do it in compliance with the rules of procedure that govern your tribunal. Combining those two requirements in a litigated case means you've got to do more than just ask for permission from the presiding judge or officer to withdraw. You've got to get the permission. You got to get the motion to withdraw granted. I was in a scenario once where I was working a case that was far out of town, and I was moving to withdraw, but I couldn't get the motion to withdraw granted before the hearing. So I got my opposing counsel's agreement to add that motion to the list of motions that would be adjudicated at tomorrow's motion hearing. Indeed, opposing counsel agreed that that motion could be heard first. So I got the motion heard first, and that's one way to do it. But notice, under my facts, I traveled out of town. I went to the hearing, and I got the motion adjudicated. Thankfully, with opposing counsel's cooperation, it got heard first. So I didn't have to sit through the rest of opposing counsel's motions. But I would have had to sit through the rest of opposing counsel's motions had the motion been denied. And this raises an important point. In those instances, which is almost all instances where the rules of the tribunal require a motion to withdraw be granted before you can withdraw, then you stay in the case if that motion is denied. McKinley, I hear you saying, but what if it's a withdrawal I've got to do? I've got to withdraw. It would be unethical for me to not withdraw. Even in that instance, if the motion to withdraw is denied, you continue the representation. But McGinley, what if it's unethical for me to continue the representation? Well, if the motion to withdraw is denied, in effect, you've been ordered to keep representing, and that order absolves you, at least until you get that order fixed, from this potential violation that you're all worried about. It would be a violation to disobey the order. So even though the order might be an error, while you're pursuing the appeal and trying to get the order fixed or filing a motion for rehearing or just talking some sense into the presiding officer, while the order is still on the books and still binding upon you, you continue to obey it. And you continue to represent because you're not withdrawn if the rules of the tribunal require an order to withdraw you and that request for an order is denied. So it's a terrible situation to be in where you know the representation has to end, but the order is not yet signed granting your motion to withdraw. But during that time period, you continue to represent. So even in a permissive situation, number one requires to avoid a material adverse effect upon your client. Notice that it says a material adverse effect. If you're vain like me, then you know you're the very best lawyer for your client. No one can represent better than you. No one can do a better job than you. You will believe if you're vain like me. So of course there's going to be an adverse effect if that client isn't represented by me anymore because there's no one better than me. But we're talking about a material adverse effect. So maybe they won't have as good a lawyer when they no longer have me, but if they have a lawyer, a sufficient lawyer, then that adverse effect might not be a material adverse effect. So that's number one. Number two, if the client persists in a course of action and you think that course of action is a crime or fraud and it's involving your representation, they're using you, in your opinion, to perpetrate the crime or the fraud. That is the second example of a permissive withdrawal under the model rules. But please keep in mind, in many jurisdictions, that particular scenario has been elevated to a mandatory withdrawal situation. Mandatory in many jurisdictions. But it's number two on the permissive list under the model rules. Number three. Wait a minute. Yes, number three. The client has used the lawyer's services to perpetrate a crime or fraud. Number three, again, shows up on the permissive list where it's on the mandatory list of so many jurisdictions. That's why it gave me pause as I looked at it. I thought, that sounds like a mandatory situation to me, but not to the good folks who wrote the model rules for the American Bar Association. And remember, the model rules aren't binding on anyone anywhere, but we study their concepts because they permeate the binding rules of every jurisdiction in one way, shape, or form, and they are the basis for that exam you're studying for, that MPRE. So number three is the client has used the lawyer's services to perpetrate a crime or a fraud. That becomes a permissive ground for withdrawal under the model rules. And I bet once you're sworn into a bar, it'll be a mandatory withdrawal in your jurisdiction. Number four, the client insists upon taking an action, but you as the lawyer have a fundamental disagreement with that decision. That meets number four for a permissive withdrawal. It's not mandatory. If you can live with the fact that your client has made a decision to pursue an objective you're not comfortable with pursuing, but you're willing to do it, then under the model rules, that's only a permissive withdrawal. It's not a mandatory withdrawal. Now, I've said this before and I say it again. We studied it before and I'll remind you again. When it comes to the objectives of the litigation, the client makes the ultimate decision. When it comes to the means of achieving the objectives of the litigation. It is the lawyer who makes the ultimate decision. So, for example, in a civil case, do I take the settlement offer or do I reject it? That's the client's decision, not the lawyer's. Do I file this particular motion seeking this particular relief in hope that it improves my client's potential outcome in this litigation? That's the lawyer's ultimate decision. So see where we draw a line there. With that reminder of where that line is drawn, maybe it was a client's decision and you find it repugnant. You don't even want to be a part of this case anymore based on that decision. That is a permissive grounds for withdrawing under Model Rule 1.16 sub 4, sub B sub 4. Sub B sub 5 talks about a client who drops the ball, who has an obligation to you as the lawyer, and the client didn't do it. What might I be talking about here? I might be talking about the moolah. I might be talking about the money. I might be talking about your payday. I might be talking about the lawyer's invoice. I might be talking about the attorney fees. I might be talking about what you are rightfully owed in that representation. The client doesn't pay, you can quit. The catch is, however, how quickly can you quit? And how much do you have to keep doing before you quit? Remember what I mentioned a few minutes ago. If the rules of the tribunal require the presiding officer, the presiding judge to approve the withdrawal, then you got to keep working until you get permission. So if you know the client's stopped paying, your contract might say among the fees that they're stopped paying include the motion to withdraw. That's fine, but collecting, actually getting that money, actually getting them to pay. You've already got a problem with the past invoices. You're probably going to have a problem with this current one, right? But yet, even though it's billable, even though it's rightfully yours, even though that's all true, they're already behind in the bills and you might end up working for free from a practical matter because they're not paying, but you've got work to do before you can stop working. See how that might be? Now, you might draft carefully your retainer agreement, your contract for hire, your contract for services, your contract between you and your client to create other obligations. For example, you might be dealing with the public. You might be dealing with individuals who don't routinely hire a lawyer, individuals who might not understand that you can't simply fail to communicate with us, clients that might not understand that you've got to provide us with information. You got to be where we need you to be. You got to tell us what you need to tell us. You got to fill out what we ask you to fill out. You have to go to the things we ask you to go to. You might want to put these as obligations in your contract for hire and underneath get your client's signature so that you can point to them and say, hey, when you stopped answering the phone when I called, when you failed to answer my email, you breached the contract. You didn't follow through with your obligations. And then you fit squarely under Model Rule 1.16 sub B sub 5's permissive withdrawal situation, because now you've got a client who failed to substantially fulfill an obligation to the lawyer. But remember this one concept because it's in there. It's a requirement before you withdraw. You got to give them a chance to fix it. They need a chance to cure. For those of you who study contracts, they need a chance to remedy the situation. You got to warn them. I'm going to quit if you don't fill in the blank. I'm going to quit if you don't come up with a way to catch up on my invoices. I'm going to quit if you don't answer my next email. I'm going to quit if you don't be at the deposition as you're required. So you got to give the prior warning. So now look at all the obligations that keep getting added onto us, even in a permissive withdrawal. We might need an order from the judge permitting us to do that. We might have to give a prior warning before we can do that. We might have to protect against a material adverse effect. We might do some legwork before. Look at all the burdens it takes to get out of a case, even when we're permitted to do it. So that reminds me to remind you again, choose your clients carefully. Choose them carefully. Choose your cases carefully. Number 6 on Model Rule 1.16 sub B's list, non-exclusive list of permissive withdrawals. Number 6 talks about how the representation might be a financial burden that you can't bear as the lawyer. You know, we're not obligated to go broke simply because we signed up a bad case or a bad client. There is good reason for lawyers and law firms to have to make profits. I know nowadays, for the perspective of some, is that the P word, profit, is a dirty word. How dare anyone ever make a profit? It's always wrong to pursue profit. It's always wrong to have a profit, some people argue. But even for those individuals who I would argue are erroneous, consider this. How am I going to continue to do good work, to represent others, to work on other cases, if I'm not making a profit on the current cases? How long will my firm survive? How long will my practice endure without profits? How can I pay the light bill? Can you imagine if the lights went out? How can I keep the lights on if I don't have profits? How can I buy the law books and the elephant, but mostly the law books, if I don't have profits? How can I wear the suit? All right, it's a cheap suit. But even the cheap suits, how am I going to wear those if I don't have profits? So much like on an airplane, you know, God forbid an airplane ever go down. But they got that little spiel that they tell you time and time again, every time you get on an airplane, even though nobody expects it to go down, about how if the oxygen masks drop from the ceiling, first put on your mask, then help others with theirs. Because of the reality of the situation is, if you don't put on your mask, doesn't matter how many more people you want to help on that airplane, you're going to run out of oxygen and you're going to die, and you're not going to be able to help anybody on that airplane if you don't have your own oxygen. Profits are like oxygen. If you and your law practice and your law firm doesn't generate any profits, you're not going to be able to help too many people, too many clients, too many organizations, too many families, too many churches, too many corporations, too many individuals. You're not going to be helping anybody at all once you run out of profits. So even for those of you in the audience who see the P word, profit, as a dirty word, I'd ask you to consider differently, especially if you're going to go into the private practice of law. So Model Rule 1.16 sub B sub 6 carves out an exception if the financial burden is too great, if it's unreasonable, or if the representation has become unreasonably difficult for not just a financial reason, but for any other reason. That's a permissive ground for a permissive withdrawal. And that's the 6. But remember, it ends with number 7. And number 7 says other good cause for withdrawal exists. When other good cause for withdrawal exists, forgive me for taking a drink, H2O. Not milk, but milk's a good thing to drink too. Whenever there's good cause for withdrawal, that's a permissive withdrawal. But now here's the harder question. When must you get off the bus? When is a withdrawal mandatory? And the simple answer is this. By analogy, when the bus is going to where you shouldn't go, that's when it's time to get off the bus. Stated somewhat differently, if it would be a violation of the rules of professional conduct to continue the representation, right then and there, that's the time to end the representation, to get off the bus. That's the first one. That's Model Rule 1.16 sub A sub 1. That's the first instance when there is a mandatory withdrawal. Another situation, subsection 2 of 1.16 sub A, is when there's a material impairment. It's a difficult thing to talk about, but illnesses strike. Physical illness can strike when we least expect it. Mental illness can strike when we least expect it. And if any sort of illness like that causes a material impairment to the lawyer's ability to represent the client, that, under the model rules, is a mandatory withdrawal. Now, I know what you're thinking, because I'm thinking it too. I don't know why the ABA wasn't thinking it when they wrote these model rules. They should have been. Our disabled brothers and sisters have rights too. And those rights aren't lost simply because our disabled brothers and sisters happen to have a license to practice law. So check the rules of your jurisdiction. Lord willing, those rules are in compliance with the Americans with Disabilities Act, unlike this model rule, which is clearly in violation of it. Just because disability strikes, that shouldn't mean that the lawyer loses her or his job. The model rules suggest that it does. And of course, that's an egregious suggestion by the model rules. I hope our brothers and sisters in the ABA can try to have more respect for our brothers and sisters who happen to have a disability, because they are among the strongest and the bravest of all of us. They're the ones that overcome obstacles to get the job done. Hey, ABA, why don't you overcome the obstacle of having a blatantly biased model rule? Why don't you rephrase it? Why don't you show some respect for our disabled brothers and sisters? So that's Model Rule 1.16 sub A sub 2. It's a disrespectful rule, and Lord willing, it has not been adopted in your jurisdiction. The last of the mandatory withdrawals, Model Rule 1.16 sub A sub 3, talks about when the lawyer is fired. If you've been fired by your client, then it is mandatory that you withdraw. Now, keep in mind the rules of your particular jurisdiction. Again, the ABA model rule, not very insightful. You have to make your withdrawal in such a way that it doesn't cause a material adverse effect. And that should be true even when you're fired. So again, ABA model rule drafters, get with the program here. Fix this model rule. Yeah, I don't know what to say. Let's talk about the actual act of withdrawing, the actual act of getting that order signed on paper by the judge or presiding judicial officer that actually allows you to quit working. How do you do it? Well, under the rules of your tribunal, there will be a way to file a motion. What I would warn you against, however, is saying much. Don't say much in that motion to withdraw. What do I mean by that? Well, sometimes the case law talks about a noisy withdrawal versus a quiet withdrawal. What's it talking about there? Well, a noisy withdrawal would be one where you spell out in great detail why you're withdrawing. I would advise against noisy withdrawals. I suggest that best practices almost always dictate that you should avoid the noisy withdrawal. Why? Well, first and foremost, remember the duty of confidentiality. It applies to both current clients and former clients. So regardless of what you might consider this particular client that you're attempting to escape from and you're attempting to get an order granting the withdrawal from, either way, you still owe that client a duty of confidentiality. So you don't want to say anything that violates the duty of confidentiality. Therefore, best practices would mean that you don't say anything more than necessary in your motion to withdraw, anything more than permitted, of course, but nothing more than necessary to get the motion granted. So I once saw a case that involved two co-counsel, and as sometimes will happen with co-counsel, one attorney thought the next best step was X, the other attorney thought the next best step was Y. The client wasn't mandating either step, and the two co-counsels could not agree. So the one co-counsel files a motion to withdraw, which is 4 pages long, spelling out what the two options were and how it was an irreconcilable difference because the first option was better, yet the option the co-counsel wanted was worse, and spelling out why that is. Not only does this get filed in the court file, but it gets copied to opposing counsel. What a noisy withdrawal that was, and completely unnecessary. Foolish, in my opinion. And who knows, depending upon exactly what was written, the motion to withdraw might have been something you could stick an exhibit sticker on and attach it to a bar complaint filed by bar prosecutors alleging an ethics violation and pursuing a grievance. Why is that? Because it might have stumbled into attorney-client privilege there, right? Might have stumbled into work product there, right? Might have just stumbled into ordinary confidential information, because surely the information reflected in that noisy withdrawal was obtained in the scope of representation. So, the noisy withdrawal is not the way to go. And I know what you're thinking. I really got to get out of this case. And this judge is a stickler. This judge is going to want to know why. Well, how about this? How about say next to nothing at first, and then if you got to follow up for a motion for reconsideration or rehearing or a renewed motion to withdraw, then say a little more later. At least then, if you end up with a noisy withdrawal, your friendly neighborhood bar grievance defense attorney can explain to bar prosecutor, my client was only doing what my client was required to do because it was a mandatory withdrawal situation and it had been denied, and it was not a good denial, and had to explain and get that denial overturned in the most expedient way. And this renewed motion or this rehearing or reconsideration motion, although noisy, was more efficient and more effective ultimately than filing a notice of appeal or dragging out the litigation like that. See how a noisy withdrawal might be something you want to avoid? I suggest that it is. So that's what we're talking about there. Another sip of the H2O. All right. So these are the kinds of things we need to worry about. And they come out of that Model Rule 1.16. But of course, your author who wrote Chapter 20, Lesson 20, ties in some other concepts other than what you find in Model Rule 1.16. She also ties in the attorney fee. And it's interesting, and it's a great time to remind us of that. We already studied attorney fees in a prior lesson, but she brings them up again here, and I like that she did. She mentions here about fees for fired lawyers, and how does that work? Well, now, if you're working for a contingency and you quit, the quitting means that you're not going to collect on the contingency. Even if after you quit, the client hits on the contingency by being pro se or by hiring another lawyer, and then there's a hit, the fact that you quit means you don't collect your contingency. But what if you didn't quit? What if you were fired? Well, now the case law of your jurisdiction is going to look at why you were fired. So if your termination was unjust, was unfair, then you might collect the entire contingent fee. Here's an interesting scenario that we see in some jurisdictions. And indeed, there is some Florida case law that suggests that in the extreme case, this could possibly be true in a Florida case. Imagine a lawyer unjustly, wrongfully fired by the client, and therefore a mandatory withdrawal situation arises under the rules regulating the Florida bar. And this was an attempt to deny a fee to the lawyer, which the lawyer would have otherwise have earned on that contingency except for the firing. So a firing late enough that you can argue the fired lawyer triggered the contingency, and under circumstances where you could argue ill motive for the firing by the client. And that client with the ill motive hires another contingency lawyer. Under those extreme facts, that client might owe 2 contingencies. Yeah, not certainly, but maybe, depending on what the lawyers can convince the judge who's adjudicating who gets what fee. But that's the extreme case, making it extremely unlikely. What is more likely is that after being fired, and not for good cause, just because, or maybe being fired for ill cause, so either one, contingency lawyer who's fired just because or fired for ill cause, that contingency lawyer has a lien upon the case to be resolved once the case is resolved. And if the case is resolved by a judgment or by a settlement, and therefore the contingency is triggered after the termination, then the terminated lawyer is to be paid through a system called quantum meruit, a Latin phrase by which we mean, in its most simple form, and this is not an attorney fee lecture, this is a professional responsibility lecture, so I'll leave out some of the details. But basically, we divide up the contingent fee between the former and fired lawyer and the current hired lawyer on a quantum meruit basis, on a fairness basis. The 2 lawyers might agree, or they might have it adjudicated by the presiding judge or presiding tribunal and have that one contingency divided up in quantum meruit. My purpose in pointing that out is the same as I believe your author's purpose in pointing it out in your textbook was, to illustrate that the rules of professionalism in the majority of instances don't end up with the double fee. It was that extreme case that we talked about where the client is going to owe a full contingent fee to the fired lawyer and the replacement lawyer. The vast majority of the time, the fired lawyer and the replacement lawyer are going to divide that one contingent fee on a quantum meruit basis. So I hope you understand what I mean by that, but to make sure, let me conjure up out of thin air an example. Okay, so you are lawyer number 1, and you've been working the case. It's a complex case. You've worked hard. You've put in 400 hours, and then you are fired for no good reason. You even ask why. I just want to change lawyers, says the client. And they hire another lawyer. There's plenty of work left to be done on the case. That lawyer puts in another 100 hours after your 400, did I say? Yeah, your 400 hours. The replacement lawyer puts in another 100 hours and then accepts sweet settlement. Now, the quantum meruit proceedings are going to have to decide how to divide up that settlement. The settlement might result in a 40% fee. So maybe it was a $100,000 settlement. So that's a $40,000 fee to be divided up between you, lawyer number 1, the fired lawyer, and your successor, your replacement lawyer number 2, the hired lawyer. So quantum meruit is not going to mean that the client pays more than $40,000, but it is going to mean that that $40,000 has to be divided between the fired prior lawyer and the hired replacement lawyer. How do you divide it? One option might be look at the hours. 300, 400 here, 100 here. So we'll give 4/5 of the fee there, 1/5 of the fee there. That's one argument. Another argument is, well, what was the best settlement offer you got during your 400 hours? Well, I got 20,000. Oh, but I settled for 100,000. So I multiplied the recovery by 5. I may have only done 1/5 of the work, but it was 5 times as valuable, says replacement lawyer. So that might come into play in the quantum merit. So there can be various arguments. You might base it on how many hours a person worked, how successful they were, how much they increased the settlement offer by. But notice with all these factors going on, we're just talking about how to divide up the 40,000. We're not increasing the fee beyond 40,000. And that's what your author is trying to spell out here for you in that book. So I think that was a great thing to add to lesson 20. And lesson 20 ends with that part C, talking about the procedural requirements, how to actually go about the withdrawal. And that's great because, as I mentioned earlier, the model rules indicate that you want to avoid a material adverse effect. You want to take the steps necessary to protect your client's interest, even though it's a permissive withdrawal or even though it's a mandatory withdrawal. Either way, you don't cut and run. You don't drop the ball. You don't jump off a moving bus. Pick the analogy you like best. Whichever analogy helps you remember that you can't have a material adverse effect by your withdrawal. And your author points out some things you might have to do in a given case, promptly turning over files. And of course, that's not a blanket rule. Under the rules of your jurisdiction, you might have a retaining lien. So check the rules of your jurisdiction. Refund unearned fees promptly. And again, which fee is earned, which fee is unearned. Check not only the substantive law and rules of your jurisdiction, check where your client signed on the line. What did they agree to when they hired you and signed that contract for hire? Third thing your author mentions is judicial approval if a judge was assigned. We talked about that. Got to file a motion to withdraw, but you got to do more than just file it. You got to get it ruled upon. You got to get an order in writing withdrawing you, assuming your tribunal is like the vast majority of tribunals and has such a rule that requires judicial approval before you can withdraw. And don't forget that last thing that your author reminds you of, that you must continue to honor client confidentiality. The best example of which is to avoid what we described as a noisy withdrawal. Speaking of withdrawing, I will now withdraw to our second break of the evening, approximately the same length as our first. And when I come back after the break, we will finally talk about chapters 4 and 5. We will finally take a look in greater detail those judicial canons, the ethics of judges. I'll be back in about 10 minutes. You still here? It's break time. Now, that was a leisurely break, right? Okay. Get the elephant on the head there. There you go. All right. Just in case you didn't have enough time to enjoy the milk, I'll put the elephant on the head so you could. There you go. All right. So thanks for sticking with me. And we are back. And our new topic, as promised, are judges and judicial ethics. What's that got to do with yours truly? Your friendly neighborhood board certified appellate practice lawyer, me, Patrick McGinley, your friendly neighborhood bar grievance defense attorney. I got my start back in law school. I was working for McFarland and Cassidy. So Richard McFarland, before he went into private practice with Marshall Cassidy, may the Lord grant them eternal rest. Both those fine gentlemen have passed on to their heavenly reward now. But back when I was in law school from 1993 through 1996, they were in private practice in Tallahassee, Florida, which is the home of the Florida State University College of Law, where I went to law school from 93 to 96. And you know what? Back then, the rules were that you couldn't work in your first year of law school. Maybe that's still the rule. I don't know. But that was an ABA rule that was strictly enforced back in 1993. So, my Lord, did I ring up the student loans in my 1L year. I couldn't wait to get to work as soon as I was allowed to do that. And I wanted to make the most money that I could, of course. And one of the highest paying firms in town at that time, if not the highest paying, I don't have firm statistics, but I know they compensated me well, McFarland and Cassidy. And the type of work they did was fascinating to me because Richard McFarland, before he went into private practice, he was a bar counsel. He was a supervisor. He was prosecuting lawyers for bar grievances and ethics complaints, working for the Florida Bar. Marshall Cassidy was the executive director. That's the number one guy, as I understand it. I guess the elected for a year and then returns back to private practice, elected president of the Florida Bar, might consider herself or himself the number one person. But the executive director is hired by the Florida Bar and serves for many years. Indeed, if I'm not mistaken, Marshall Cassidy was the longest serving executive director of the Florida Bar. He was the one that helped oversee and build that beautiful Florida Bar office that you see up on the hill if you ever visit Tallahassee. If you have a license to practice law in Florida, a drawing of that beautiful building is displayed prominently at the top of your license to practice law. That was Marshall Cassidy's work, among many, many other wonderful things he did while being executive director of the Florida Bar. But he was in private practice with Richard. Marshall was when I got to work for him over at McFarland and Cassidy, or to be exact, McFarland, Wiley, Cassidy, and Jones was the name of the firm while I was there from 94 to 96. And the type of work that Richard and Marshall were doing was fascinating to me as a young lawyer. They were defending their fellow lawyers against bar grievances and ethics complaints, which I now proudly call myself a bar grievance defense attorney because of the skills that I began to learn while working for those gentlemen. But one thing they did that was part of that practice and equally fascinating to me as a law student was defending judges. They defended judges against judicial complaints. And if you're familiar with how that works in Florida, you know that any old person for any old reason can file a complaint of ethics violations against the judge, and unscrupulous non-lawyer litigant might even do that hoping to gain an advantage or out of spite. Perhaps for that reason, the rules state that when a grievance is filed against the judge, there's a hush order. There's an order that requires that nobody talk about it. So, and that's important, I think, for judicial integrity. Before the complaint is vetted, before it's investigated, before there's a finding of probable cause, I think it's a great idea that there be some hush orders, that there be some silence because of that risk of improper motives or just an uneducated or uninformed party being misinformed about what a judge's role is. We don't want breaking news every time such a complaint is filed. So the reason I bring that up is there I am, a law student, and there I am at McFarland, Wiley, Cassidy, and Jones, and walking through the halls would be Judge so-and-so or Justice so-and-so. And wow, I'm meeting Judge so-and-so or Justice so-and-so. Maybe as a law student, you can relate. Certainly when I was a law student, it was like meeting a celebrity. It was like meeting a star. Meeting a judge is like, wow. And I really wanted to rush home and talk about it. I wanted to tell my friends I'd met Judge so-and-so or Justice so-and-so, but I could not. I couldn't tell anybody because of the hush order. It was the policy of the firm that you don't even mention that Judge so-and-so is here to have lunch with Marshall or Justice so-and-so is having lunch with Richard today. Whether or not they were there for a grievance or a complaint or not, you just didn't mention that they were there. And man, I had to bite my tongue. I wanted to talk about it. But I tell that story, not just because I love that story, but because I think it illustrates a point. And it illustrates a point that when we're dealing with the judiciary and we're dealing with judicial ethics, we're dealing with a whole different animal. The rules that govern judges and judicial ethics are not the model rules of professional conduct that govern lawyers. It's a completely different set of rules. And the first thing you see there, if you're following along with me, and our required readings in lesson 4 or chapter 4 of our textbook is bold and all caps. So I guess the author's shouting at you, right? If it's in all caps, bold and all caps and underlined about how the model rules of judicial conduct are separate from and not the same as the model rules of professional responsibility. So we got a whole different rule book when it comes to judges. And the premise of that whole different rule book is a whole different premise. This premise applies to judges, not to us lawyers, just to judges. Judges must avoid even the appearance of impropriety. Under the judge's rule book, different from the lawyer's rule book, the judges, not the lawyers, must avoid even the appearance of impropriety. So something that would yield just an appearance of impropriety is not necessarily a violation of the model rules of professional conduct that applies to lawyers. Indeed, it's not the premise of the model rules of professional conduct that applies to lawyers to avoid the appearance of impropriety. Compare that to the model rules that govern judges. The very premise of the judicial rules is for judges to avoid even the appearance of impropriety. So it might not be improper. It might just look improper. The judge under the judicial rules must avoid it because the judge must avoid even the appearance of impropriety. So that's why your author suggests, and I would humbly agree, that judges are held to a higher standard. What's the higher standard? To avoid even the appearance of impropriety. That's a higher standard than lawyers are held under the model rules of professional conduct. Now, Judicial Canon 1 of the model rules talks about the integrity of and the independence of the judiciary. And now we have some overlap, right? Especially when it comes to integrity. We've got our own model rules of professional conduct that apply to lawyers. Our chapter 1 certainly talks about independence of our profession. Likewise, Canon 1 talks about the independence of the judiciary. We value in our society an independent judiciary. While I was doing some research for a law review article that I published last year in the Albany Law Review, I read about some history of the founding of our nation and how the independence of our new judiciary and our newly founded United States of America was of utmost importance to our founders. We find it talked about in letters and pamphlets. We see it talked on the streets, according to historians, and a point of debate. Our founders were quite concerned with the fact that the king signed the paychecks of the king's court and the king's judges. And our founders, even before our nation became our nation, were looking for a method of an independent judiciary. So the canons of judicial conduct and their concern about the independence of our American judiciary has a long and storied history, going all the way back to the founding of our nation. I found that fascinating. That wasn't exactly what I was researching when I was writing that law review article, but I went off on that tangent. Can you imagine McGinley going off on a tangent? When do I ever go off on a tangent? Constantly, right? I hope it helps to make these lectures lively and entertaining. At least that's the point of these tangents. So the independence of the judiciary has always been of utmost importance to our nation and remains canon 1 of the model rules of judicial conduct. Also, the integrity of our judiciary is reflected in that model rule. Rule 1.2 certainly talks about the integrity of the judiciary. Now, to avoid that appearance of impropriety, the model rules that apply to judges are far more intrusive into the personal lives of judges than the model rules of professional conduct are to lawyers. By way of comparison, there's far more intrusion into the personal life of the judge than there is for the lawyer. So memberships and things of that nature come under scrutiny when it comes to judges, whereas they're not under direct scrutiny under the model rules that apply to lawyers. The Code of Judicial Conduct, that model code in its Rule 2.3 and elsewhere, reflects the intent to avoid bias and prejudice in all of its forms. I've complimented our nation before, and I'll compliment it again as being on a constant quest of self-improvement. I love the fact that each generation of Americans tries to make America a better place for the next generation. It's a beautiful history that America has. And likewise, the model rules are attempting to weed out any sort of bias or any sort of prejudice in our judiciary. And that is a noble goal. When it comes to harassment, judges are certainly the enforcers of discipline in their tribunal, and they are seen on television banging the gavel, boom, 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 order in the court, order, yelling at the bailiff to go do this or enforce that. And of course, there's a time and a place for everything under the sun. There's a time and a place in the real world to act like those dramas you see on TV. But the model rules are attempting to have judges not be a source of harassment. They shouldn't be harassing either the lawyers or the parties or the witnesses. Indeed, the model rules, in their attempts to rule out bias and prejudice, urge and require judges to show a modicum of respect to the lawyers and the parties and the witnesses that appear before them. So a judge cannot discriminate in any way, either on the bench or off the bench, through a membership or a personal habit or behavior in the courtroom. You can see on the books judges that have been disciplined for harassment and harassing behavior that did not take place in the courtroom, was not directed toward a party or a lawyer or a litigant. Certainly there are cases on the books where that has happened. Those resulted in discipline. But there's also cases on the books where discipline was imposed for behavior that happened behind the scenes, where a judge was disrespectful to staff in the office or on the street. We all have our web browsers. We all hit the star or the bookmark or the save for our favorite stories. One of my favorite stories, I can only paraphrase, but it involves 3 judges on a weekend at a fast food restaurant parking lot, shouting insults at a car and getting into a fight, a physical altercation with the driver of the car. I mean, wow. And they were disciplined for that, and rightfully so. Are judges human? Are judges people? Yes, humans make mistakes. People have their flaws, but we're holding judges to a higher standard. If you're interested in reading that bookmarked website story of mine, let me know. I'll gladly email you the link. It's a hoot to read this story. It's unbelievable how these judges went out on a town, allegedly had too much to drink. I think it wasn't even a fancy fast food restaurant they were at. Got into this physical altercation in the parking lot. This story, you read it and you scratch your head thinking, these are judges? But allegedly, that's what happened. So I can send you the story if you want to read it. So whether it's on the bench, whether it's off the bench, judges have to avoid the appearance of impropriety. And in so doing, they're held to a higher standard than we lawyers are held. Is that good or is that bad? Well, it has a long and storied history, and it is what it is. I'd argue it's a good thing. Maybe you'd argue against it and say it's a bad thing, but it's probably a good thing. Now, a judge, in order to avoid the appearance of impropriety, there's certain things that they should not do and cannot do that a normal citizen is allowed to do. Your author gives some great examples. Being a character witness, joining a discriminatory organization, using non-public information. No. All 3 of those things are forbidden. The judge can't voluntarily appear as a character witness, can't voluntarily be a member of a discriminatory organization, can't make use of non-public information. Those 3 things are not permitted. What about the fact that a judge, in most instances, has to be a practicing lawyer? Does that mean the judge can continue to practice law? And under the model rules, the answer is no. The license to practice law can remain current. So the judge doesn't have to resign or give up the license to practice law. Indeed, many statutes of many jurisdictions will require a judge to be a licensed lawyer. But that's not a prerequisite in some jurisdictions, in some courts. If I'm not mistaken, you historians out there can correct me if I'm wrong, weren't there justices of the Supreme Court of the United States who weren't lawyers in time long gone by? I think there were. In a given jurisdiction, it might not be a requirement. In Florida, it's certainly a requirement. Florida's Constitution, for example, requires that any justice of the Supreme Court of the state of Florida have been a lawyer. Not only that, but the justice must have 10 years as a practicing member of the Florida bar before becoming a justice of the Supreme Court of Florida. You might know that because it was in the news quite recently. As we talk today, there is a justice who has been recommended by the Judicial Nomination Commission and has been chosen by Governor DeSantis to be a justice of the Florida Supreme Court, but she won't be taking the oath just yet. She'll be waiting a few more days because that brief little time waiting will mean she will have had her 10-year anniversary as a member of the Florida Bar, and her 10 years of membership will mean then she can take the oath and start working on the Supreme Court of the state of Florida. So that's one example. Another example is Florida's workers' compensation law. That creates an Office of Judges of Compensation Claims, which are a type of administrative law judges. That is a separate division underneath and within the Division of Administrative Hearings, which is our administrative law judges. And those ALJs in DOA, Division of Administrative Hearings, within DOA is the OJCC, the Office of the Judges of Compensation Claims, and those administrative law judges, the Judges of Compensation Claims, the JCCs, who resolve the petitions for benefits filed under Chapter 440, Florida's workers' compensation law. They have to have not only a membership in the Florida bar, but a minimum number of years of experience, not just practicing law, but practicing workers' compensation law. So depends on your jurisdiction, depends on your tribunal, depends on your relevant statutes. It's exactly what experience an individual needs in order to become a judge. But you can do it. If you aim for the judiciary, you can get enough experience. You can get the relevant experience. You can qualify. And it's a wonderful way to serve the public. If you have any interest in it, I would encourage you to get the knowledge and experience and memberships you need. But most importantly is to get that judicial demeanor. You know, if you're going to meet the standard of avoiding even the appearance of impropriety, you're going to have to conduct yourself with a particular demeanor, are you not? You're going to have the right characteristics and the way that you carry yourself and act in all kinds of different circumstances. And we've all appeared in front of different types of judges. Some are grumpy, some are not. Some are jolly, some are not. I've been in court where I've put on an evidentiary hearing in front of a referee, in front of someone who's adjudicating a bar grievance. And the rapport was right, the judicial demeanor was right, where I might be able to crack a joke. I've done it. I've cracked a joke during an evidentiary hearing. You got to know your judge, or at least know your joke. If you're going to dare to crack a joke in a courtroom, in a bench trial, in a jury trial, but the right judicial demeanor is what's needed to be a judge. I've appeared in front of some judges. Their demeanor is one of customer service, for lack of a better description. They're there to serve. They're there to get the job done. They're there to enforce the law by its terms, but to do so in a attitude of service. And that can be an adequate judicial demeanor. I've appeared in front of judges who they are committed to the concept that justice is blind, which I hope any and all judges would be committed to seeing themselves as an umpire, as a referee, as calling balls and strikes, as not hoping it's a ball or hoping it's a strike and trying to transform it into a ball or transform it into a strike if they can bend the law. They're more straight up interpret the law in such a way as to read it and apply it, not interpret the law in such a way as to bend it or to have it serve a goal. To me, that's the better judicial demeanor, is to apply it, not to bend it. To me, the better judicial demeanor is read the law, apply the law to the facts, and reach an outcome, not because you as the judge were aiming for an outcome, but because that's the outcome that an unbiased reading of the law requires. That's the perfect judicial demeanor, in my opinion. Opinions differ. Maybe you prefer the kind of judge who has a political agenda and is there in kind of like a super legislative role. Maybe you prefer that kind of judge. I don't. Maybe you prefer the kind of judge who says, the people through their elected representatives have decided what the law should be until I preside and reinterpret it in another way. No, 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 no. In my opinion, that's not what a judge should be doing. In my opinion, that's not the proper judicial demeanor. I think it's horrible for a judge to say, I'm the super legislature. I'm the replacement for the will of the people. I get to dictate to the people what their laws will now be transformed into. In my opinion, that's the wrong way to be a judge. In my opinion, that's the wrong judicial demeanor. But with all that said, to what extent can a judge get away with it, for example? Is it a violation of the judicial conduct rules to interpret the law in a political way? And for that, I would turn to my book over here that I pull off the shelf. I believe I have it here. And what I've got in this book is some citations to the rules of judicial conduct, and to what extent does it make it unethical for the judge to have a political leaning. That's what I'm addressing in more than one of my books. The one I just happened to pull off the shelf is this one. So I'm referring to chapter 3 of this book, which I titled Canons of Construction and Judicial Restraint. And there I talk about this topic, about judicial ethics and constitutional interpretation, because this book had a constitutional topic. But whether it's the Constitution or anything else, I think this holds true. And I quote from this Nova Law Review article to say that over the years, scholars and courts have employed a wide range of methods for analyzing constitutions. Some principal methods include deriving the meaning of the Constitution from the pure and literal meaning of its text, which the authors of this Nova Law Review call a textualist approach. Another option they talk about is finding meaning in the intent of the framers. The authors of this Nova Law Review article call that the originalist approach. And another one is treating the Constitution as a living document that must be interpreted to conform to the immediate needs of modern society, which these authors of the Nova Law Review call an interpretist approach. How about that? A living document, huh? So the Constitution, I guess it's got a heartbeat, I guess, because it's a living document. I guess it has feet, right? I guess it's running. Did you see that? Did you see something go by? Was that the Constitution? Oh, my Lord, the Constitution just flew off the bookshelf here, and it flew past you. Did you see that? Oh, it just went again. Did you see that? A living Constitution. It sprung alive. It jumped off these bookshelves, and it flew right across your screen. Did you see that? Whoa, there it goes again. The living Constitution. It's alive. Watch out. It's flying around the room. Crazy idea, right? That's just an excuse for judicial activism, right? To say that the document is a living Constitution. I got a 10-year-old son, and he was indoctrinated, educated by his teachers that there's an idea of a living Constitution, right? So he wanted to know if I'd heard of this. So I said, oh, yeah, I can even give you an example, I said. I said, how would you like to have chocolate ice cream for dinner? He's 10 years old. Already he's suspicious. He knows dad wants him to have a healthy dinner. I said, come on, we'll put it in writing. So I wrote it down. You can have chocolate ice cream for dinner. We both signed it. I went into the kitchen. I came back from the kitchen with a big bowl of broccoli. Dad, that's not chocolate ice cream, he said. We wrote it down. We signed it. Yes, that's right, I said. But what we wrote down and signed was a living document. And by chocolate ice cream, I have interpreted that to mean broccoli. So there you have it. There's the concept of a living Constitution, right? A living Constitution is this. It's an excuse for those who are in power to impose their will upon others, right? I have power over my son. I imposed my will that he eat a healthy dinner, despite the fact that our living document said chocolate ice cream. So there you go. So now, if you turn to the public, the non-lawyers, what do they think? What do they think of judges? And we got right here in my book a quote from the February 2014 survey by the Pew Research Center. It concludes that about half of the public, 49%, say that the decisions of the U.S. Supreme Court should be based on its understanding of what the Constitution means in current times, while roughly as many, 46%, say decisions should be based on what the Constitution meant as it was originally written. So, the public may not see it as a bad thing that bowl of chocolate ice cream can be interpreted to mean steaming hot bowl of broccoli, right? The public may not see it as a bad thing, but maybe you do. Yeah, that's your opinion. Another survey I talk about in the book here suggests the public perceives constitutional interpretation as something done not according to rules, but instead along partisan lines. Yeah. I quote here from a March 2017 survey by C-SPAN and by Penn, Schoen, Berland. Hope I pronounced that right. Penn, P-E-N-N, Schoen, S-C-H-O-E-N, Berland, B-E-R-L-A-N-D, PSB. It concludes, quote, 62% of voters say that U.S. Supreme Court justices are split on political grounds like Congress, and concludes that just barely more than 1 out of 3 voters, or 38% of voters, say that the U.S. Supreme Court acts in a serious and constitutionally sound manner. Robert Green, principal at PSB, which has conducted 11 national public opinion studies in the High Court, including 6 studies commissioned by C-SPAN, opines that the public's perception of the U.S. Supreme Court as a partisan political entity did not form overnight. A direct line can be drawn between President Obama lecturing justices during his State of the Union address and later President Trump openly criticizing decisions and judges by name. The High Court's decision to remain literally out of sight has hurt rather than helped their reputation. Quoting from press release, new C-SPAN PSB survey, American Attitudes About the Supreme Court, dated March 17th, 2017, and as found at that website there, that I quote in my book, Interpreting Florida's Constitution. So, are judges political? Are they not political? Well, if you ask the public, like they did in those surveys, seems like the public answers that question. Yes. And that brought me to quoting from this large article here of Amanda Frost, written in the Georgetown Journal of Legal Ethics. And she talks about these laws and how they might prevent judges, at least federal judges, from acting in a political or biased way, which is the goal of the model rules, certainly. She talks about 3 different statutes governing recusal of federal judges. And a recusal, of course, is a formal motion that one might file asking a judge to no longer preside for a myriad of reasons that would make presiding improper, such as an alleged bias or a showing of bias. But 3 different statutes govern recusal of federal judges, according to Amanda Frost's Georgetown Journal of Legal Ethics Law Review article 26, Georgetown Journal of Legal Ethics 443. Only Title 28, Section 455 of the U.S. of the U.S. Code applies to the Supreme Court, she points out. She also talks about a Federal Ethics in Government Act of 1978, and that one requires annual reports where judges publicly disclose aspects of their finances. She also talks about an Ethics Reform Act of 1989 that puts limits on outside earned income and gifts from all federal officials, including federal judges. She talks about a Judicial Council's Reform and Judicial Conduct and Disability Act of 1980 that authorizes anyone to file a complaint alleging that a judge has engaged in conduct prejudicial to the effective and expeditious administration of the business of the courts. She talks about the code of conduct for United States judges. That's not a federal statute, but rather a set of ethical guidelines adopted by the Judicial Conference. And she talks about whether these ethics laws are even constitutional. She says, although a few critics, including some of the U.S. Supreme Court justices themselves, have raised constitutional concerns about applying ethics laws to the Supreme Court, there's been no focused academic analysis of Congress's authority to regulate the justices' ethical conduct, according to Amanda Frost in her article called Judicial Ethics and Supreme Court Exceptionalism. So, what is this exceptionalism of which Amanda Frost refers? She refers to being an exception, how the Supreme Court can be an exception to these rules. But my book then focuses not just on Supreme Court justices, but focuses on Florida justices, because my book was about the Florida Constitution, not just the U.S. Constitution. And what we found there, at least what I suggested was a conclusion, is that being either a textualist or some other type, such as interpretivists or whatever the other ists were that were talked about, that falling under one of these categories of being an ist wasn't necessarily a violation, that it couldn't be prevented by the Florida Code of Judicial Conduct. So perhaps you might find the same as you continue to study the Model Code of Judicial Conduct. There is enough room there that judges might either purposefully or inadvertently either lean one way or lean another. In my opinion, there should be no leaning at all, but the possibility of leaning, it's certainly there. So that was a deeper dive into your author's chapter 4, part Roman numeral 3, parts A, B, C, and D. Let's pick up again from that book and look at part E of Roman numeral 3 of chapter 4, lesson 4. And that talks about no compensation for extrajudicial activities. And that was a bold statement by your author and not entirely true. There is certainly some exceptions to that rule. For example, compensation for conduct which is becoming of a judge. The examples include what I'm doing right now, teaching a professional responsibility course, or teaching any other law school course, or teaching a continuing legal education seminar, or teaching a civics lecture, or any sort of college or high school class. Assuming that's done for pay, the judge can accept the pay for that kind of activity, because the case law tells us that the rules are properly interpreted, that there isn't an appearance of impropriety when a judge takes on an educational role. Same can be said for certain writings, writing books, writing law books. Maybe you know somebody who does that, writes these law books that are sitting behind me. To the extent that a judge might do that, the judge can do it for compensation. That's okay. Next part that your author talks about are ex parte communications. Those are to be avoided. What are they? They are one-on-one conversations with just one side of the litigation. All sides of the litigation should be present, should be able to hear, should be able to object, and should be able to be heard whenever a case is discussed. There are statutes that allow certain activities to proceed ex parte. For example, probates and estates are often handled, at least parts of them, if not all of them in some jurisdictions, on an ex parte basis. There are other ex parte hearings which are appropriate under the substantive law of a given jurisdiction, unless the substantive law allows for ex parte, the judicial canons require the judge to avoid ex parte. An exception would be on non-substantive matters such as scheduling. But in my experience, most judges have staff and delegate that task. If a judge receives a communication on something other than a non-substantive matter such as scheduling that the judge believes is ex parte, then the judge, under the ethics rules, is obliged to share that written communication with the other parties in a reasonably timely manner. When it comes to trial publicity, the judicial canons discourage it. A judge who's presiding over a matter is not supposed to be making extrajudicial statements about that matter while it remains pending. It's not necessarily the case once it's resolved. We've all seen interviews with judges in either historical context or in other contexts where they're talking about war stories, if you will, or stories from the bench or cases in which they presided. Some might even write a book after they get off the bench, as long as it's done in compliance with the particular judicial conduct code that applies to their jurisdiction, then that's okay. Some other sources of compensation which are appropriate are identified in Roman numeral 4 of chapter 4 of your text. I recommend reviewing that list. It includes the fact that the Code of Judicial Conduct, Rule 3.15, requires a report of that compensation, just as we heard from Amanda Frost in her Georgia Journal of Legal Ethics Law Review article. Likewise, the Code of Judicial Conduct requires such reports. Judges cannot be compensated when working for non-family or non-personal corporations. However, law, teaching, lecturing, or writing is okay, according to paragraph B of your author. Reimbursement for expenses must be limited to the actual cost of travel, lodging, etc., according to paragraph C from your author. And judges can receive compensation for extrajudicial activities, but the standard is reasonableness, says paragraph D of your author. Reasonableness being the standard, and impropriety, remember, is the overall standard. Your author says reasonableness is the standard, but I would have phrased it differently, because the overall standard is to avoid the appearance of impropriety. So even if that's reasonable compensation, from whom did the compensation come? And does the source of the compensation or other factors mean that there's not true impropriety, but an appearance of impropriety? Remember, the judge has to avoid even the appearance of impropriety. So based on that higher standard, I don't know that I would have phrased it exactly as your author did in paragraph D, but I did like the way she phrased paragraphs A, B, and C of part 4. And one thing she did was to break out into its entire separate chapter, chapter 5 or lesson 5, more details about judicial conduct, which she puts under the heading outside activities. Speaking of outside, I'm going to walk outside for about 2 minutes to get a breath of fresh air. So this is our final break of the evening. This one's just 2 minutes long, so don't go too far, please. And when we come back, we'll wrap up not only chapter 5, but we'll wrap up our last recorded lecture of our semester. So as you wait 2 minutes with bated breath, I'll go outside and get some fresh air. Then I'll come back inside, talk about judicial conduct and outside activities. Be right back. Thank you for that quick break. It was nice to get outside and get some fresh air. Speaking of outside, our final chapter and our final topic tonight, which I'm going to breeze through because you put up with me for over 2 hours so far. And for, 3 credit hours equals what? A lot of hours of lecture. This is it. This is our final lecture. So let's get this wrapped up and send you on your way to passing with flying colors, not only my final exam, but the MPRE exam. Lesson 5 from your text, judicial conduct outside activities. Non-judicial activities are okay as long as they don't distract or detract from the dignity of the office and they don't involve an appearance of impropriety. Remember, the judge must avoid even the appearance of an impropriety. So civic activities, charitable activities run a great less risk of an appearance of impropriety than the kind of activity that is neither civic nor charitable. So what about giving financial or legal advice? This could run into an appearance of impropriety because who is it you're speaking to? Would they later appear before you? So you got to watch out for that kind of thing. Financial activities have to be what your author calls above board. Got to be fair. Got to avoid that appearance of impropriety. What about fiduciary activities? Well, if it's a family member, there's a close family relationship, then the judge can serve as the executor or executrix, the personal representative or the administrator or other fiduciary of the estate plan, assuming this is an estate plan that's going to have a possibility of appearing before that judge for adjudication or for processing. So it can't be both the judge and the party, obviously. It can't be both the petitioner and the judicial officer. So there's a limitation right there. If you're acting as a judge or an officer, you can't practice law. We covered that earlier. If you're going to be appointed to something, make sure if you're the judge, that you're appointed to something that's for the improvement of the law. That's the kind of appointment that a judge can accept and avoid the appearance of impropriety. Obviously, on the flip side, if somehow the organization is discriminatory, then that's not the kind of appointment that the judge should be accepting. What about politics? And this can get tricky because some judges are elected, particularly here in Florida, elected. So as SCOTUS reviewed within the past 48 months, we've got Florida rules that say a judge can't solicit directly campaign financing. What the Florida rules require instead is that the judge set up a committee, and it's that committee that solicits the financing for the judge's election or re-election campaign. So it may seem a minor thing that, the judge appoints a spouse or best friend or child or parent to head up a committee, and it's that spouse or best friend or child or parent as committee chairman or chairperson that solicits the funds. But according to SCOTUS and according to Florida statutes, that's enough. And that's the minimum. And that's required. So there should never be a situation where you're handing money to a judge. And there should never be a situation where the judge accepts the money. For example, on a couple of occasions, I'm practicing 23 years, so this happens to everybody eventually. I've had the pleasure of having a lunch or a dinner, and at the lunch or dinner was the judge. And the judge is quick to make sure that the judge has a separate bill and the judge pays that bill because it's just that appearance of impropriety. Maybe I'm picking up the check for everybody at the table and the judge happens to be at the table. The judge is going to say, no, I want a separate check, and the judge is going to pay their own way. It's just an application of this rule of thumb to avoid even the appearance of impropriety. The judge needs to be impartial. Your author covers that. Judge needs to be diligent. Your author covers that. Judge needs to be fair and courteous to all in the courtroom. We mentioned that earlier. That includes the jurors too. But as your author mentions, you neither condemn nor criticize the jurors. You thank them for their service and that kind of thing, and make sure that they're comfortable. And please let the bailiff know if you need anything. But you don't say, "Well done, jury." and you don't say, bad job, jury. So you're certainly courteous. You're certainly a good host if you're the judge, but you're neither condemning nor criticizing the jury. And your chapter ends to avoid whistleblowing on judges or lawyers and cites to Code of Judicial Conduct 2.15. And just as that ends chapter 5, so too does it end this video. I would close with the following advice. Your textbook is a relatively short one. I think you'd agree, compared to many of the textbooks in your other class. Read it, then reread it, then reread it again in order to help you prepare not only for my final exam, but for the MPRE and for the effective and efficient and ethical and moral and zealous practice of law. It has been my great honor to have you as my student. It's been my great honor to teach professional responsibility at your law school. I tell you, I mentioned time and time again how I defend my fellow members of the Florida Bar and District of Columbia Bar against bar grievances and ethics complaints, and help by giving ethics advice, because I love my profession. I love the law. I love a nation of laws, not of people. I love the rule of law. I love our independent judiciary, and I love what our judicial system stands for here in the state of Florida and in all 50 states, the District of Columbia, and our territories, and throughout this great United States of America of ours. I tell you, I mean it when I say it is an honor to practice law here in the USA. And as you too will soon see, it's an important job too. Our focus today has been on the role of the judiciary in avoiding even the appearance of impropriety. But that's a beautiful standard that you can apply to yourself as a lawyer if you choose to do so, even though it's a higher standard than our rules apply. And you might think of the rules of professional conduct as a floor, a bare minimum below which you cannot sink. But that doesn't mean you shouldn't reach for the ceiling, reach for the sky, reach for the stars. By doing just the bare minimum, you're just that. You're the minimum. But by reaching for the ceiling, reaching for the sky, reaching for the stars, you become something even greater. You become someone who is a credit to our profession, which I know you can be, and I humbly suggest you should be. I hope that I am, and I hope that I have been of service to you in your studies. It's been a great semester for me, and I hope it was for you too. Keep your questions, comments, and suggestions coming. Reach out to me in the usual way. I'm always happy to hear from you. And that's true not only now when you're my student, but at any time in the future. Nothing flatters me more than when I hear from a former student about anything or nothing at all. It's just always flattering to hear back. So keep me in mind. Call on me if you will. I will respond. And I thank you for this semester together. Until we meet again, may God continue to bless us all. Thank you, and good night.